We have already on the table the representatives of the defense. Mr. Karim Khan, yes, you have the names there already, is the defense counsel for Mr. Ruto. And you have also the defense counsel of Mr. Sang, who is Mr. Kipchumba Kigen-Katwa. You can also address to them your questions after listening to their statements. I give you the floor.
Ladies and gentlemen, thank you for your time and for your courtesy in attending to hear what the defense have to say. You've patiently listened to what the registrar put forward and also what Madam Prosecutor postulated. One thing to remember is that Kenya, of course, is not in the dock. Kenya was a great nation of great potential before this ICC case, and it will remain a great nation full of potential after this ICC case. But the focus of the defense and the focus of this institution must be laser-like. We have every right not to request, but to demand a fair process, to demand a fair trial. And for that, of course, we have a role to play as Defence Counsel, just as the prosecutor has a role to play, as does the legal representative of the victims, and of course, supreme above all of us are the judges who have to fulfill their own oaths of office. You will hear tomorrow, at the opening of this case, what a lamentable shambles the prosecution investigation has been. A parody of justice. And unfortunately, it can only be described as a whole-scale duping of an office that has been put in place to protect the rights of victims. I must, with the greatest of regret, take issue with only one issue, with what His Excellency the Registrar said. Those that, like me, that believed in the formation of the ICC had high hopes for justice. These mantras that nobody is above the law, that there should be accountability for all. But the reality is not that at the end of this process we will know who is responsible for the violence that befell Kenya in 2007 and 2008. That's what His Excellency the Registrar hoped for. We will not know who was responsible, but we will know who was not responsible. It's a fundamental distinction, and in my view, I've had the honor of representing victims in Cambodia. I've been a prosecutor in the Yugoslav and Rwandan courts. I'm not somebody that I hope has a parochial or a narrow view as to the interests of justice. But the investigations have been so palpably deficient, the judges will have a very difficult task. And I don't want anybody to be seduced or bought into the nonsense that is being bandied about, that the weaknesses of the prosecution case are somehow because of malfeasance, intimidation, bribery, some kind of underhand conduct by the defense. Because I've just come from court number 1 in a public hearing, and I reiterated what a member of the prosecutor's own office said, the senior prosecuting trial attorney, that he has stated that there is no suggestion whatsoever of any inappropriate conduct by anybody in the defense team for His Excellency William Ruto. So then what? What happens with all those arguments about intimidation and blackmail or inducements or all the rest of it? The simple, inescapable reality is this, that after 3 years, millions of pounds of international taxpayers' money funding this prosecution, not one person has been brought to book for intimidation or blackmail or improper practices. This case will fall apart in the end. This is what we will submit to the trial chamber tomorrow. It will be done so by a decision of the trial chamber after hearing the evidence. But it will be done because of lack of evidence, because of the wrong target selected, the deficient investigations that were conducted, and not for any other reason. So let's try to blow away the smokescreen that is being raised to hide what we say are the deficiencies, unfortunately, of the OTP. On a personal level, I have great regard for Madam Prosecutor and also her deputy, James Stewart. I have no questions regarding their personal integrity whatsoever. They're good people. But on any view, it is our submission that this office got off on the wrong track from the beginning due to the conduct of the previous prosecutor. And that wrong footing that infected the very foundations of the ICC OTP has contaminated this case as well in a very remarkable and very real way. All these are matters that the defense will raise in the course of trial, and of course the veracity of them will be decided by the defense by the judges in due course. I want to say something to all of you today, particularly my brothers and sisters from Kenya, in the hope that it is relayed in clear and unambiguous terms. And I have said it before, and it's been relayed before in the Kenyan media, that not as Karim Khan QC, but as the lawyer representing His Excellency William Ruto, on his instructions, we want all individuals to allow the prosecution and the defense to do its job. No one, whether for the prosecution or for the defense, should feel at risk, feel intimidated or coerced if they tell the truth. We do not want witnesses to withdraw. We want witnesses to come here and tell the truth. Because what the truth will show, we will tell the court, is that there has been a cabal put together that have concocted stories that have been swallowed hook, line, and sinker by the prosecution. And those witnesses should come to court and tell the truth. We assure all witnesses that in line with our professional code of conduct, of course, the court is looking after them, the prosecution will look after them, and we will also deal with them with proper respect. But in the same way that we want witnesses to tell the truth, everyone should be on notice. There should be no uncertainty that whether a witness lies for the defense or lies for the prosecution, it is a most serious offense to commit perjury. As the prosecutor said, and as the registrar said, it's an offense under Article 70 of the Rome Statute that can result in imprisonment. And in fact, it is an offense that should result in imprisonment. Because this court, this building, the people within it on all sides, prosecution, defense, registry, and judges, cannot fulfill the lofty aspirations that this court was founded upon unless witnesses tell the truth. And whatever the benefits or the inducements or the asylum or the relocation or whatever the difficult situation people may find themselves in, no one should sell their soul to lie. So those that tell the truth, welcome. And those that wish to deceive the court, they should be on notice that perhaps it's not as easy to deceive as people may think. Thank you for your attention, and those are my comments on behalf of His Excellency William Ruto. I will now pass to my learned friend for Mr Sang.
Thank you, ladies and gentlemen, for this opportunity. What I would wish to say is more specific to Mr Sang than general terms. Mr. Sang maintains that he's innocent. As most of you must have seen, he is one tiny man who is compensated with a good voice and integrity. And it is our position that much as prosecutor has put emphasis on victims in terms of people who suffered as a consequence of the violence, there is the part of the fact that Mr. Sang himself is a victim, and we would have wished that the prosecutor also gives attention to that. Mr. Sang himself has cooperated, and even when these issues of witness interference is being bandied left, right, and center, Mr. Sang maintains that he has cooperated and has kept away from the witnesses and has left his confidence in being able to demonstrate his innocence. I must make the observation that it was a pleasant surprise to hear the registrar indicate that as far as the registry is concerned, and in that sense, the International Criminal Court, he's satisfied that Kenya and the accused have cooperated with the court. That, we ask, should be juxtaposed with the litany of the allegation by the prosecution that the country and the accused have sometimes not cooperated. It is our position that we've cooperated, especially Mr. Sang. It is our perception, as in terms of Mr. Sang, that the country, Kenya, has also cooperated. And we are very glad that some people notice, even if the prosecutor has not noticed that. It is an unfortunate situation, and we need to say this on our part, that we do not contest that there was violence in Kenya. The question that will be an issue would be who. And tragically, the prosecutor has failed in that because he's brought people who are completely innocent, more particularly in terms of having brought Mr. Sang. I think I should not lose this opportunity to indicate this, that Mr. Sang came to learn for the first time that he's a suspect when the prosecutor, the predecessor of the prosecutor who sat here, announced his name. And the importance of that highlight on my part is to pose the question as to what difficulty there was in affording Mr. Sang an opportunity to react to the allegations made against him before his name was announced. And we think this is a serious issue that a court of the international stature that it is, or more specifically its prosecutor, would for the first time mention the name of a suspect without giving him a chance to react to the allegations made. And this applies not only to Mr. Sang, but to a couple of people who are said to have been in the company, in association, and in some sort of conspiracies with Mr. Sang. And we think it is extremely tragic that all these people have not been given a chance and have been deemed or treated as suspects or criminals by the prosecutor without giving them a chance. And it is an issue that we take very seriously. I should say, in explaining that Mr. Sang has no problem on the integrity of the current prosecutor. And I underline and emphasize on the current prosecutor as vis-a-vis the previous one. The issue of the witness withdrawal has come up a couple of times in this session. We wouldn't want to say much except to point out that as far as we are concerned, if there are any witnesses who have withdrawn, it must be in terms of their putting on scales the choice between having to say the truth, their conscience, vis-a-vis having to come and lie in court. And so the issue of witness intimidation is an issue that we do not necessarily agree with. It is our view that those witnesses must have done what they did out of their conscience, and they need to say the truth. Lastly, it has been said by the prosecutor that this case has ended up in this court because Kenyan officials asked for that. I wouldn't want to speak on behalf of Kenya or the Kenyan officials that the prosecutor is referring to, and whom I don't know, but I would like to say that that position does not represent Mr. Sang. Mr. Sang believes in Kenya, believes in its judicial functions, believes in its institutions, and maintains the position that Kenya could discharge justice and could have discharged justice better than what the prosecutor has put together. The case against Mr. Sang is a product of conspiracy, which, in fairness, the prosecutor should be prosecuting. Thank you, ladies and gentlemen.
Open for questions. Let's start there.
My question goes to Mr. Khan. My name is Felix Olik. I work for Standard Newspaper Kenya. I want to know whether you've made an application or you will be making an application so that the president and the deputy president don't appear for the trial at the same time. Thank you.
I think a lot has been said about this, and of course such an application will be made. The only additional thing I'll say, and it will be decided by the court on its merits, but in assessing the viability and the appropriateness of that application, let's leave aside the Constitution of Kenya for a moment. The reality is that this court has only one courtroom that can deal with the case against the Deputy President and also the President. There's two courtrooms in total. And there are other cases ongoing. So in any event, as is patently obvious, there has to be an alternation of the various different cases, so every individual can have proper time in court and have their case heard and disposed of quickly. So it will really be no prejudice that one can see if the interest is proper scheduling and nothing else, to make to vary the schedule so that the Deputy President is here for one period and then His Excellency the President for another period. It won't delay anybody's rights, but of course it would help remove the strain of the domestic responsibilities and the rights of all the millions of people of Kenya, that their elected officials, the head of state and their deputy head of state, runs the country in discharge of the mandate given to them by the people of Kenya. So I think there's no really countervailing argument against having the president and deputy here at different times. That there's no reason that must necessitate them being here at the same time, and every reason against it. And I think in what we would hope is that the court, whilst doing justice blind to all individuals, of course it must have also some regard to certain realities regarding that every person's case is different, and the case of a president and a deputy president may have different factors to consider than somebody who is no longer in office or somebody who doesn't have those responsibilities. And those are not improper considerations to bear in mind as long as no prejudice is being caused. And the question is, what prejudice could possibly be caused by requiring the president and the deputy president to stand trial at different periods? We say none, and that's the application that we'll put forward to the judges in due course, and the judges will determine it on its merits. So I hope that answers the question.
More questions?
Hi, my name is Zubeda from KTN Kenya. Would you say that the Office of the Prosecutor has cooperated with you in this case? Have they made it easy for you to make yourself ready for the case?
We have said repeatedly that, and both this case and case number 2, that there's been systemic failings in the prosecution. I've said in court on my feet that unfortunately the disclosure regime is not fit for purpose. I do not recoil one word that I uttered, because those are not the words of the defense. The judges themselves have vociferously criticized the prosecution. One only needs to read the dissenting opinion of a very eminent judge, Her Honor Judge Christine van Wijngaard, who not only has had the privilege of being a judge here, She's had the privilege of being a judge at the Yugoslav Tribunal and a judge ad hoc at the International Court of Justice. And she has, in withering terms, appraised the prosecution's disclosure obligations. Just in the last 2 weeks or so, even Judge Trentafilova, the pretrial judge who confirmed the case, spoke in effect of the prosecution tardiness, their dilatoriness, their incompetence when it comes to acting in a proper and timely fashion. Even here we are today with trial tomorrow. And the reality is, it was an open session. There are 2 witness statements of 2 new witnesses that the prosecution is going to rely upon that we haven't seen yet. So if one reviews this conduct from the time of before the time of confirmation, it's characterized by giving the defense necessary information, not at the last possible minute, but very, very late in the day, to the extent that it has the very real capacity to prejudice the defense. And we've said that in court. We've made these applications in court. Unfortunately, what we want is a very professional prosecution. I'm glad that there's a new senior trial attorney now in situ. He seems to be an experienced individual. I hope with the steering of the new prosecutor and the new deputy, that a time will come when they will manage to deal with some of the systemic failings of the OTP, so that other accused in future cases are not prejudiced to the extent that we have been. But perhaps it's too little, too late for us. So that's my answer to your question.
So are you afraid that it might...
Sorry, just a minute. There is another question here.
Thank you. My name is Evelyn Nyoike, Raw Media Services. There are feelings that if the charges of either of the accused, especially the president and the deputy president, if either of them is dropped, there could be tensions, especially tribal tensions from the country. What's your view on this?
You know, it's a new Kenya today. A new country was born with a new constitution, a new Chief Justice, a new DPP, a new police force, an Inspector General, a devolution of powers, and we have a coming together of a government, of a country, represented by the new government. Of course, it's no secret that the president and the deputy president come from different ethnic tribes. And also, it's no secret that the government is a broad church representing people from coast, north, south, east, and west. So I think the Kenyans, after seeing the horrors of 2007, 2008, realizing their potential and everything that lays ahead of them with the new constitution and with good governance, I hope that they will cavil, they will repudiate anybody that wishes to incite to violence, to thuggery, to mischief, and comply with the rule of law. Because ultimately, this court is not doing anything, or the principles upon which this court is built are the same as the principles that are enshrined in the Kenyan constitution, is that people should be able to live freely without fear and progress and fulfill their own dreams. So I hope that whatever is the result, people of Kenya are mature enough and wise enough to want justice, and that's also what we want here for the defense.
Please go ahead.
Okay, my name is Linda from Ghetto Radio 89.5 FM Nairobi. The former prosecutor Luis Moreno Campo had a famous saying that Kenya will serve as an example to the rest. And this has come somehow to haunt the office of the prosecution, even with the new prosecutor. Do you believe, as a defense counsel, that Kenya is being victimized by the ICC and especially your defense? And also being the defense counsel, what's your comment on the ongoing motion to get us out of the Rome Statute? Do you believe it's a right idea?
You know, it's very important for all Kenyans and for all observers to draw a very marked distinction between the office of the prosecutor and the institution of the International Criminal Court. They're not the same, they're not coterminous. The prosecutor who sat in this chair is procedurally identical to me. She may have a very huge position and very great responsibilities and be world famous and very different from a humble defense counsel, but before the court, we are identical. We trust, and we have no option, I have no option but to trust the judges, to trust the rule of law. And in my experience, that whatever hurdles are encountered, whatever mistakes are made, in the end, it tends to be the case that justice is done. You know, we can't be too quick to, in my view, to criticize the judges. Because remember, it's these judges of the trial chamber that rejected the prosecution arguments to excuse the attendance of the deputy president from trial. That's their finding. And so I have confidence that they will do their jobs, they will weigh the evidence, and given the massive, and this is not rhetoric, you'll be there in court throughout these proceedings, the massive systemic failings, the refusal to look at evidence that is somehow inconvenient to their case, their refusal to look at the motivations of their own witnesses, all of these aspects pollute this case, and we're confident that when as long as we do our job properly, the judges will do theirs.
Could we take in, sorry, just a minute, the last three questions, please. There was a question there, that lady, second row. She was already waiting. After her, you.
It is a follow-up question on what I asked. You've said that you've not gotten the match you needed from the office of the prosecutor. So will it, or might it affect your defense, or how confident and ready are you to face her in court?
It is true that the position of the defense is that the prosecutor has not been very forthcoming and has not been very helpful. And I think it's a fairly moot issue because the court itself has made a decision on that aspect of it, that in fact the prosecution has not been very diligent. I think there is a need also to look at the other dimension to that point, being that the failure on the part of the prosecutor is not a mere default. It's actually, as far as we are concerned, a design to sabotage the defense. And we think that is really unfortunate. I should also say, I would also want to say something about the issue of whether Kenya is a victim or not. On the part of the defense, we maintain that Kenya is a victim. We also maintain the position that the accused, and I would just want to put emphasis on the fact that Mr. Sang maintains that he's a victim. And it was interesting to hear the prosecutor come forward without any prompting to say that the people on trial are individuals, not a community, not an entity. We would ourselves react and say that in fact, what is on trial, first of all, is the prosecutor himself or herself in the manner and style of investigation. The second that is on trial is whether Kenya is an existing entity, an institution, a government institution, whether it is a state. And this trial is meant to ridicule Kenya as a country and the Kenyan institutions and to create the impression that it's a jungle. And this is tied to the question of the defaults on the part of the prosecution to give disclosures and to cooperate with the defense. Every time that default has arisen, the one line that the prosecution maintains is that there are security issues. I would imagine up to 90% of the people seated here have been to Kenya and must be very astonished at how secure Kenya is vis-a-vis the impression and the picture that the prosecutor attempts to make, that Kenya is such a dangerous place where you have to go with, where nobody is secure, including witnesses. And lastly, on the issue of whether or not Kenya is a victim, and I would like to remind people here that the logic of the prosecutor's case was that there were two communities who were fighting and could never sit together. These are exactly the same communities who the Kenyans have entrusted the governance of this country to. And so I would also like to invite this congregation, this assembly, to find an opportunity to laugh at the prosecutor's logic and theory in regard to this case. Thank you.
We are taking the last question. I'm sorry, there is no more time. Please, sir.
Wow. Mike. Yeah, Counsel Kigen, thank you. In your opening, this is Boni Musambi from KBC Kenya. In your opening remarks, you strongly insisted that Mr. Sang is a victim himself, and you're wondering why the prosecution hasn't realized that. So does it mean efforts are underway to have him included in the victims list? And to Counsel Khan, you came out strongly to attack the evidence that prosecution has so far. That may be taken as mind game, just as we witnessed between us and Wenger and David Moyes. What say you about that?
I'd rather be Alex Ferguson. But the question is, the judges will decide the veracity of the defense. It's not the first defense case I've been involved in. It's not the first defense case my team has been involved in. And we're not in the habit of making wild, speculative submissions that are not based upon evidence. If we did, our reputations would not survive a case, never mind decades. So the judges will decide the veracity. I'm here, I accepted the invitation to come here to answer your questions, to give honest answers to what I hope are sincere questions. And I've given those honest answers. This is what I believe, it's not only what I'm saying. And I think what I'm saying probably will come to pass. But the judges will ultimately decide, and I hope those stations and those newspapers that are sending you will make sure that you can come frequently enough to observe these proceedings, because it's very important that people in Kenya and internationally don't hear the views only of the parties, but have journalists also that critique events. The only caveat I ask, because whilst the Kenyan press is very robust, it's very vigorous, there's no shortage of articles or no shortage of, there's no lack of candor. I do hope that it's not politicized and that individuals will report evidence as it unfolds and not advance the cause of any interest groups or agendas for purposes that are not related to the truthful reporting of proceedings. On behalf of His Excellency William Ruto and the defense team that I lead, I can say that we want things to be accurately reported, because if they are accurately reported, it will simply make the decisions of this court and the proceedings of this court more transparent and more understandable. Thank you.
Thank you very much. I would like now to... Oh, I'm sorry, you want to add something? Sorry.
No, I don't want to add something. I want to answer a question that has been put to me. The question is, in what terms Mr. Sang is a victim? Mr. Sang is a victim being a Kenyan in the sense of the after effects of the violence. And that is in general terms. But in more specific terms, Mr. Sang is a victim in different sense. That is a victim of the might and the weight of the prosecutor. The prosecutor whose powers are uncontrolled, and the prosecutor whose regime is the reason why America couldn't join in as a state party, being that he is not supervised, he is not governed, he is not controlled. And that is the sense in which I'm saying Mr. Sang is a victim. He's a victim in the sense that he's being tried either because the language in which he spoke was not understood. Everything that could not be understood in the Kalenjin language that he spoke, he's treated as a criminal offense. And that is the sense in which I'm saying he's a victim. Thank you.
Okay, thank you very much. I would like to invite to take the floor to the legal representatives of the victims. Thank you.
Good afternoon, ladies and gentlemen.
Good
afternoon, ladies and gentlemen.
If I may introduce you, just for the sake of giving your name to the media, the legal representative of the victim is Mr. Wilfred Nderitu, and he will give his statement now.
Thank you. Good afternoon. Okay. I think I would want to begin by reminding us that 2007-2008 was not the beginning of wars for the citizens of Kenya. A lot is forgotten about 1992 and 1997, when there were other episodes of politically instigated ethnic violence. And if you think about 1992, you would see that a person born that year would now be 21 years old. That is 3 years above the age of majority in Kenya. Yet, those who suffered harm in 1992, those who lost their loved ones then, and those who were displaced, were never regarded as victims until 2007, 2008. That is when the word victim in the context of criminal justice in Kenya started being used. Before that, we only had internally displaced persons without any focus whatsoever on the trauma and re-traumatization that people who had suffered earlier did suffer in 2007, 2008. Now, 2007, 2008, therefore, only represents the elastic limit of victimization of the Kenyan public. And if we look at the statistics, and I don't like very much looking at statistics, but if we look at statistics, we are talking officially about 1,133 persons killed. Now, if you look at the immediate nuclear family size, which on average would be, say, 5 in Kenya, then you are talking about 5,500 plus people from nuclear families directly affected by the post-election violence. We are here perhaps about 80 people. That's just a 14th of 1,133. In short, the people killed, according to official estimates, although unofficial estimates are much higher, would be 14 times the press briefing that we have here. And I say this because if, and God forbid, we were to have one person here collapse and die, it would affect us tremendously. How much more would it affect us to have not just one person, and not just two, and not just the entire population here, but 14 times this population dying, and not dying because of pre-existing medical reasons, not dying out of suicide, but dying only because they did not have to die. Now, if you look at the people that were displaced, we are talking about 650,000 people, which is 2/3 of 1 million, approximately. That is a number that would represent very many cities around the world. It's a big number. And we must always remember this as we think about the violence that took place. Now, since 2007, close to 6 years now, those who suffered direct harm, physical harm, loss of their dignity as human beings through various gross violations to their rights, and those who lost loved ones, and also others who had to leave locations where they had lived in for many years, are still waiting for justice. It's close to 6 years, and we sometimes forget and remember very much the ICC process, which came itself well after the violence. And I think by any standards, again, 6 years is a long time. And so it has been a long road to justice for the victims, and they're hoping that through the process that starts tomorrow, they will be able finally to find justice. It is very often thought that the criminal justice process is a contestation between a prosecutor and a defense. Yes, the prosecution is important and the defense is important too. But I think what is even more important is the victim, because without victims, there would be no need for justice, because there would have been nobody affected by, there would have been nobody affected by any crimes that would be alleged to have been committed. So let us bear this in mind, and what I would want, and I hope that the media will be carrying me through this, is to ensure reportage that is going to very, very clearly bring out the unheard voice and the cry of victims. It's not always very, very newsworthy to talk about victims. It's not newsworthy to talk about people who are destitute or who have been left destitute by a system by a system. But please remember, even as you report about what the defense is saying, as you report about what the prosecutor is saying, you bear in mind the victims that are there. So it is my hope that the long road will, or the long journey will be well on its way to a destination which will be letting the victims know exactly why people that lived side by side with them for sometimes 5 years, in other situations much longer than that, would just take up arms against them and get them out of places that they so cherish. Thank you.
Okay, the floor is open for questions. Please, sir, microphone here. Yeah, thank you.
Thank you. My name is Nzao Musau from The Star. My question is related to what you've just said on the issue of victims. The victims have been under extreme pressure to accept and move on, in quotes. Accept and move on, forget about the victimhood that was visited upon them. Some of them are already pulling out, as you might be aware. Where does that leave your situation as the person representing the victims? When victims themselves, initially it was about witnesses pulling out, but now we are seeing even now victims who are, like you explained, the role of victims is not really to indict the accused, is to narrate their their victimhood. But now they are pulling out. Where does that leave you as their representative? Thank you very much.
Thank you, Mr. Musau. Now, I think I would want to start my response to you by, first of all, saying that a lot about victim withdrawal, while there is some truth in it, there has also been ample amplification by the media itself. As we stand here, we are talking about one incident that related to a letter involving 93 persons, all of whom claimed to be case victims within the case known as Kenya 1, which is the case against Mr. William Ruto and Mr. Joshua Arap Sang. Now, out of the 93, just a number that's about half of that is what can be ascertained to be case victims. But apart from that, even with that number, about half of the 93, the truth of the matter is that there have been lots of inconsistencies with regard to, say, signatures purportedly made by the victims and also previous signatures that they had provided to the court. And that begs the question as to the authenticity of the withdrawal. I know in Kenya it has become fashionable to say that Kenyans have moved on. But I would want to be confronted by a person who claims to be a genuine victim, who suffered physical harm or who was forcibly displaced or who lost a loved one, and the person says that he or she has moved on. There may be such people, but I'm sure there will be few and far between.
Ambassador, please.
Thank you very much, Mr. Nderitu. Of course, as you know, all the victims are Kenyans, and their families are Kenyans, even the people that passed away. Bearing in mind what we have seen, the process that has gone on, and the flaws and the issues that have come, do you think the victims would have been better served by a different process other than this ICC process? And what do you hope to get for these victims at the end of it? And I'm asking this in view of other ways of looking at the issues, like a home-based system, if there's one, or where we can say, if you lost whatever you lost, you can be resettled or you can be paid. I think it's happening now. And I think a lot of victims are realizing probably this is a better system than sitting and waiting many years of a system that is not working and that seems to be wrought with a lot of issues. Thank you very much.
Thank you. As to whether the plight of victims can be addressed through another mechanism, there can be many mechanisms, but I think it's important to underscore the fact that any mechanism that is not founded on justice is a mechanism that is founded on quicksand. People want to know, and as I said, it's not just about 2007. I think we need to go down memory lane and remember all those other episodes and find what will be a lasting solution to the periodic political violence in Kenya. So I'm not saying that there is no place for other mechanisms, but they must be grounded in justice first and foremost. So we cannot move on to phase 2 before we are through with phase 1. And phase 1 is about international criminal justice. I think having failed domestically to have our own justice system address the plight of the victims.
BBC Africa.
There's a question. Peter Musembi from BBC Africa. And your predecessor in this case, that's Sureta Chana, had sought to have additional charges included, I think particularly because there were arsons which were not read anywhere in the charges, are you pursuing the same, or does it remain as it were right after the pre-trial?
Thank you for that question. We are not pursuing any charges, any other charges apart from those that have been preferred by the prosecutor. And I think it is important to bear in mind that the mandate, the prosecutor has her mandate, the judges have also their responsibilities, and the decisions that would be made or that were made were based on investigations that were carried out, and it is on the basis of those investigations that decisions were then made to prosecute initially decisions were made to have 6 persons appear before the court for confirmation, for a confirmation hearing. And after that, 4 of them were found to be of concern so far as prosecution is concerned. And of course, as you know, one of them then was let go. So the mandate of the common legal representative does not go so far as to decide who ought to be prosecuted, because in making a prosecution or in making out a case to prosecute, the prosecutor would obviously also need to look at various things such as where does she have the evidence, or where did the previous prosecutor have the evidence. And it may very well be that there are other people who, according to our own personal notions, may be responsible and who ought to be tried. But I do not see that any prudent prosecutor would also be going against a person if they do not know where they're going to get their witnesses from.
Last question, please.
Both. When the prosecutor visited, my name is Evelyn from Royal Media Services. When the prosecutor visited some camps in Kenya, the victims said they don't believe in the witnesses in front of the court, or those who are expected to give their evidence in front of the court for the cases. And they said they know who the real victims are. What is your take on this?
Sorry, the victims said that they know who the real victims are?
Yes. And they said they don't believe in those witnesses that the prosecutor is using against the accused.
Well, I think I can only leave that to the process that is starting tomorrow. At the end of the day, the prosecutor will line up her witnesses, and if there is no basis upon which the case can be proved, then the case would be thrown out. But again, sometimes it's we find situations where people may take a very simplistic, if I may, view of the violence that occurred. And it may very well be that I may be seeing somebody and saying, so-and-so is the one who should be before the court, because perhaps they attacked me directly. But those who attacked me directly may not necessarily be the ones who will be coming before the court. And there is a lot, and this is really not within my field, but within the prosecutor's field, as to determination of which victims to call, why they are being called, what links they're going to draw between the various crimes that have been alleged.